The ongoing litigation between Atiku Abubakar and Chicago State University, which Tinubu sought to join, and the judgment was delivered against him, eventually he appealed. Now the verdict has been delivered by Honorable Judge Nancy Maldonado. While making her ruling, apart from the reprimand, she made it clear she ordered Chicago State University to make sure they deliver all the documents that Atiku requested before noon on Monday, 2nd October 2023. Their oral deposition must be done before 5 p.m. the following day. On the reprimand, she told Tinubu that they will not entertain any further appeal, that it will be denied. Of course, he can go to a higher court, which is the 7th District Court, to appeal, but it doesn't look like he will get a stay of execution because of the timing. This is because, according to this latest ruling, by noon tomorrow, Atiku Abubakar will be in possession of Tinubu's academic records from Chicago State University. Looking at how swift the judgment was delivered, there's no way you can't envy the American justice system. No matter what you feel, no matter your reservations about what is going on in the United States, you can't help but give them thumbs up, because the judge was able to recognize the urgency of this matter. And if you look at the whole hearing, how she handled everything, you understand that there is a sense of judgment, understanding of everything. The deadline at the Supreme Court in Nigeria for submission of everything, all further evidence and replies, is on the 5th of October. So if that deadline passes, then all the effort that Atiku Abubakar has put in to the matter will be wasted. It was easy for the judge to make her decision, just like it was easy for Honorable Judge Gilbert at the lower court to make his own decision. Because looking at the two certificates, it's obvious that this one is forged. Chicago State University attorney also accepted that they don't know where Tinubu got the certificate from. And looking at CSU's website, this is a form that a former student can fill out in case he wants a new certificate or diploma, like they call it. So one wonders, why didn't Tinubu fill out this form in order to receive a new certificate from Chicago State University? Meanwhile, during the proceedings at the Presidential Election Petition Tribunal, he filled out this form. As you can see, look at the documents he requested Chicago State University to release to him so that he can tender in court to prove that he actually attended the school, which wasn't in contest anyway. One wonders why he didn't fill out the other form on their website in order to receive another certificate instead of downloading it from Pinterest. And looking at this form again, you can see that there is a checkbox for tuition records. Remember that Chicago State University said that they do not have any tuition records for Tinubu, that they do not have his international passport, that they do not have any information or record on how he paid for the tuition. So if they have this checkbox here, that means they must have the records. So why are they not releasing the records? Why is that of Tinubu different? So looking at all the controversies, you can see how easy it was for the judges involved to make their decision on the discovery. Also, Tinubu didn't help himself by arguing exactly the same thing on appeal. When one files appeal, it is expected that the person will focus on new information or mistakes on points of law from the judgment. But coming to appeal to make exactly the same arguments, the judge must have seen that this person is trying to hide evidence, unlike what happened at the appeal court in Nigeria, where the judges started making excuses on behalf of the respondents. INEC dodged subpoena. They even lied in court when they answered that one of the documents demanded by Labour Party wasn't available, that they do not have the document. In the end, their witness presented that same document that was requested under subpoena. All this happened in front of the judges. They didn't do anything. Instead, they started making excuses, manufacturing reasons for the respondents. Imagine saying that Shettima did not intentionally commit double nomination. This argument was never made by the respondents. How in the world did they manufacture a reason on their behalf? It's very strange. The judges never upheld any single relief sought by the petitioners. It's very strange. Instead, they upheld all the arguments of the respondents, including manufacturing new ones for them. So saying that they were biased is an understatement. Many people thought that 25% is the surest that they must uphold because it is written in the law in black and white. But they ended up rewriting that section of the 1999 Constitution in order to arrive at a predetermined destination. It is very, very shameful. Nigerians can get justice abroad, but in their own country, they can only dream of it. Look at Ibori. If Ibori was tried in Nigeria, he wouldn't have been convicted. Maybe a judge would have boldly released him, but he was jailed abroad. This Atiku's case in Chicago, if it were to be in a Nigerian court, you already know what they will do. They will delay it unnecessarily. By the time they deliver judgment, it will be of no use. Justice delayed is justice denied, but that's not how it is applied in Nigeria. They will delay you into frustration. In fact, their attitude borders on relegation of duty. They know that this is urgent, but they will not act. Look at all the litigations that many parties brought before the inauguration. They threw some of them away. Some judges ran away. They were not to be found. Do your job or you make way for another person to do the job. It's as simple as that. Why should judges be afraid of delivering judgment? Are they waiting for other parties to respond in kind? It's very strange how they operate. Another thing worthy of emulation from the US court is the fair hearing. Despite it being obvious that Tinubu was making the same argument, the court still allowed him, they gave him that fair hearing. Everyone has a right to be heard, but you can only dream of that in Nigeria. When judges turn against you and start insulting you, look at the wording of the judgment, one page. But in Nigeria, they will insult the petitioners, not just reprimand, but outright insult. Imagine a judge saying, are we going to go to the market or social media to get evidence on your behalf? So they were too biased, they weren't even pretentious. The same electoral law they didn't want to uphold is the same law that other election tribunals across the country are using to disqualify candidates. Look at what happened in Kaduna. Despite throwing away the PDP candidate's petition based on technicality, they still looked at the matter on its merit. Yes, there's a lot of confusion after that judgment, but they actually upheld Obasani's win. While looking at the merit of the petition, they accepted that the failure of INEC to upload the results in real time affected the results in these polling units. So 2-1, they declared that INEC should conduct a rerun in this election because the number of voters in that area are higher than the margin between the two candidates. So they declared a rerun, but it will not have effect because already they have used technicality to knock off that part of the petition. So that's why the PDP candidate is going to appeal. So a bystander will be asking, is it not the same electoral law that appeal court judges said that it didn't matter, that there was nowhere in the electoral law and the Nigerian constitution that it mandated upload of polling unit results in real time? By 12 noon tomorrow, Atiku Abubakar will be in possession of evidence that will finally disqualify Tinubu. That's only if the Supreme Court will do the right thing. Remember that this evidence is not new. It has been in the public since last year. And this same evidence was submitted at the appeal court during the election hearing. But you all know how the appeal court justices threw away everything. So, Atiku has gone to court to get this evidence in his own capacity as a candidate, directly given to him, not Enahoreba or someone else. So it will be interesting to see how the Supreme Court will handle the new evidence. That's why we keep saying that we shouldn't be blaming all foreigners or former colonialists for our problems. Look at how they did their own part. They didn't hide any evidence. They upheld the law. The judge said that the discovery must be made. Let's know who is lying. Let's know who is telling the truth. Corruption is the major problem in Nigeria and Africa at large. Let's see how the Supreme Court will handle the new evidence and make their decision. And be rest assured, we will bring you the bombshell release immediately we get them tomorrow. Thanks for watching.